I haven't had a relationship with the child, and she's told me before that she doesn't even know if this is my child. And she showed me pictures before of somebody else holding a child that be potentially the child's father. That they were a lighter skin complexion than me, and I don't think I'm the father.
We're back on the record in cause number DF 2500246, Edwards and Boyd. With the parties in the Edwards and Boyd matter, please raise your right hands. Do each of you solemnly swear or affirm that the testimony you're about to give in this cause will be the truth, the whole truth, and nothing but the truth? Ms. Boyd?
Yes.
Mr. Edwards? I can't hear you, Mr. Edwards.
Yes.
Okay, thank you. You may both lower your hands, and Ms. Peoples, you may proceed.
Thank you, Judge. I'll first need to do service on the record for the mother.
You may.
Ms. Boyd, can you state your full name?
Yes, Christina Boyd.
And did you receive an email from our office containing the petition and suit affecting parent-child relationship that was filed in your case?
Yes, yeah.
Do you understand you have a right to be personally served with that petition?
Yes,
Are you in agreement to waive personal service and to accept the petition through your email?
Yes,
I'll pass the witness, Judge, and ask that the record reflect that Ms. Boyd has agreed to waive service.
The record will so reflect.
Thank you, Judge. Judge, so the state filed a petition and suit affecting parent-child relationship. There's one child on the case, Altino Logic Boyd Edwards. I'd offer as State's Exhibit A the acknowledgement of paternity that was filed with the pleading, Judge.
State's Exhibit A is admitted.
Thank you, Judge. I believe Mr. Edwards is requesting DNA for that child. However, the state would object because there is an acknowledgement of paternity on file. I can take testimony from parties on the issue.
Okay. How old is the child, Ms. Peoples?
2. He was born in 2022, so he's 2.
Okay, thank you, Ms. Peoples. You may proceed.
I'll call the father, Mr. Edwards. Can you state your full name?
Tommy Edwards.
And Mr. Edwards, you are requesting that there be an order for DNA testing for the child, Altino Edwards, subject of this case?
Correct.
Okay. And why are you asking for DNA?
I haven't had a relationship with the child, and she's told me before that she doesn't even know if this is my child. And she showed me pictures before of somebody else holding a child that could be potentially the child's father. That they were a lighter skin complexion than me, and I don't think I'm the father.
And you understand that you did sign that acknowledgement of paternity, which stating that you were the child's father?
From my acknowledgement, I only signed the birth certificate at birth. I didn't know it was a acknowledgement of paternity. She told me that we were gonna she would allow for a DNA test, and it never happened.
Okay, I'll pass this witness, Judge. If I could call the mother.
You may.
Ms. Boyd, are you also requesting DNA, or do you agree with the request for DNA?
Yes, I am actually requesting DNA as well. Yes.
Okay. And is there anything you want to tell the judge as far as why you're also requesting it?
Actually, because at the time, I was, you know what, at the time, his dad is actually, right now, he's in the Navy, and we were supposed to go and do a DNA, all of us together, me, him, and Tommy, but when the time came, I guess, they both didn't have their money at the time to do the DNA so that we could do the DNA, but yeah, that's the only reason I was requesting DNA.
Okay, I'll pass the witness, Judge.
Then I'll order DNA testing. What day is this reset to, Ms. Peoples?
Judge, so the reset date would be September 17th.
So this case will be reset to September 17th, 2025 at 8:30 a.m. You will both need to be present on that date and at that time. You will also need to participate in the DNA testing on the date that the agency schedules you or as close to that date as possible so that the results will be available when we return to this court on September 17th. Mr. Edwards, for you, do not sign paperwork if you don't know what you're signing. And if you're not sure that you're a child's father, please don't sign paperwork, okay? Saying that somebody's going to give you DNA later. Ask for the DNA before you sign the paperwork. There are lots of judges in the state of Texas who will not allow you to have DNA testing, and you would just be this child's father and you would just be paying child support. So remember that in the future, okay?
Appreciate that.
All right. Anything further, Ms. Peoples?
Nothing, Your Honor.
Okay. Then thank you guys for appearing here today. And you have a question, sir?
I'm in the state of Alabama. Is it a way we can get the
they'll schedule you, sir.
will I get it in the mail or email?
The AG's office will probably email you, but they might mail you. So you need to be looking for it through both mediums, okay? All right. Anything else? Then thank you both for appearing here today, and you're both free to go.
All right, thank you.
We're hearing a suit affecting the parent-child relationship. First, has the court take judicial notice of the temporary order signed by this court on April 3rd, 2025.
So noted.
And Judge, if I could state the terms of a proposed final order and then take testimony.
So it's not an agreed final order. Is that correct?
Not on the issue of child support.
Okay. You may.
The terms of the temporary order will be made final, and the parties agree to that, with the exception of the amount of child support that the father would be ordered to pay. That is in dispute. The issue of retroactive child support was not addressed in the temporary order. There's an agreement that there will be a retroactive child support judgment against the father in the amount of $800 as of April 30th, 2025. And
800 and what?
$840.
Okay, thank you.
And that will be as of April 30th, 2025. That judgment will be payable at $30 per month beginning July 1st. Additionally, court costs would be as billed to the father. On the issue of child support, at the temporary orders hearing, there was a contested hearing on that matter. There was a determination by the court that, as you can see in the temporary order, that Mr. Fadairo had a clothing business and works as a Lyft driver. And the court make a finding that his child support should be $420 a month, but there was no other evidence that the state was able to provide regarding his income. Father's requesting that that be reduced, and the mother's requesting that it be increased. So if I could call the parties for testimony on the issue.
You may.
I'll begin with the mother. Ma'am, would you please state your full name?
My name is Cecilia Osaji.
Miss Osaji, we're having a problem hearing you. So can you turn your camera off and let's see if we can get a better connection.
Can you hear me now?
Yes, ma'am. You can go ahead.
Thank you, Judge. Okay, ma'am, did you hear the terms of the proposed final order that I stated to the court?
Yes, sir.
With the exception of the child support amount, are you in agreement with the terms of that proposed order and believe it would be in the best interest of your child?
Yes.
Okay. Now, with respect to the child support, do you have any information related to Mr. Fadairo's employment status or wages that you did not have at the time of the last hearing in April?
No.
Why is it then that you are requesting that Mr. Fadairo's child support be increased?
Our agreement, we agreed on before I got another job that he'll pick up my daughter. Daycare ends at 6 o'clock. So I get off at 6:15 and I pay $65 a day in late fees. So he doesn't pick her up on his weekends. He's actually making it hard for me to work. So that's why, really.
And any other reason?
And then I'm pregnant for him again right now, so.
I just want to confirm, you are still in agreement to Mr. Fadairo having visitation with the child should he choose to exercise it, correct?
Right.
All right. That's the witness, Judge.
May I call your next witness?
I'll call the father. Sir, would you please state your full name?
Fadairo.
Did you hear the terms of the proposed final order that I stated to the court?
Yeah,
Do you understand those terms?
yeah,
And with the exception of the amount of child support that you would be ordered to pay, are you in agreement with those terms and believe they're in the best interest of your child?
yeah, but I can't afford the fall training.
I'm saying with the exception of that amount, are you in agreement with the other terms?
Yeah.
Now, with respect to the child support, do you have any information related to your job or your wages that you can give to the court today that you did not provide in April?
No, I don't have any more information there.
Okay. So why is it that you're asking that the court change her determination as to what the child support should be and lower it today?
Yeah, because I'm still owing because I have other kids on child support. I'm owing the Attorney General $7,000. So if I keep paying this one, it's gonna keep accumulating. I don't have a regular job now. I don't know. Maybe in future I might have a regular job and increase it. You understand? Because I'm owing a lot of money there, and I have two extra kids over there. Plus this is the third one, so I can afford it. But I paid the temporary one. I had to sell some of my items. I paid the first one you ordered me to pay. I made the payment. She called me that she didn't receive the money. I don't know. So I don't know.
Okay. Is there any other reason why you think the monthly amount should be changed?
Yeah, I can't afford it. I can't afford it. No other reason.
Ask the witness, Judge. Nothing further.
Okay, then I will make the provisions of the temporary order final. I will accept the agreement on retro, and I will order child support at $420 per month as it was in the temporary order. Are there any questions?
No
Okay,
question.
now that I've made my ruling, if you don't like it, if you think it's not fair, if you don't agree, you have 3 days to appeal, 30 days to file a motion for new trial. This is out of the 301st District Court. That's Judge Mary Brown. She might have a different opinion of mine. Now that I've given you that information, does anyone have any questions?
No question. I'm fine. I'm fine with it. That's okay.
Okay. If there are no questions, then everyone is free to go.
All right. Thank you, ma'am. You have a good day.